Hello, everyone. You're welcome to this edition of the AGI Virtual Law Practice course. This is another edition entirely. The reason being that what we are going to discuss today is technically different from what we have discussed, before. Uh, um, we are going to look at some emerging realities in virtual law practice. The things that are important for uh, lawyers, for the lawyers of today to take into account in the virtual law practice. Virtual law practice has come to stay. We don't want to make this class, this CPD series to look too serious. In other words, we have adopted a unique approach in our learning facilitation system. We make it look simple. Just feel free. We don't want it to take the to where the to take the form of rocket science. So when we say rocket science, you understand what we mean. We want you to see it as something that is achievable, something that is easy, something that you can practice with fun. That's the unique thing about the course. So, in today's class, we will be discussing some emerging realities in virtual law practice, some areas in virtual law practice which you need to really have at the back of your mind as a virtual lawyer, or as a lawyer who wants to practice as a conventional and virtual lawyer. Uh, these emerging realities in virtual law practice are important. We cannot run away from them. One of them is data privacy. Your client has a data. You are a lawyer. You are in charge of the processes of your client, the court processes of your client. You are in charge of relevant information concerning the case that you're doing for your client. You are you owe your client a duty to keep his processes um, secure. You owe your client a duty to protect uh, his or her privacy as far as the matter is concerned. There are some um, documents that are supposed to be in your custody by virtue of the fact that you are the person doing the case, for that particular client, and you have a duty to keep them uh, as a virtual lawyer in soft copy format, as it were, not just the conventional hard copy approach. So these are some of the emerging realities which we are going to discuss in virtual law practice, in this virtual law practice series. So we want you to sit back and uh, get your pen, your paper, and jot one or two things down which may be of benefit to you in your practice as a virtual lawyer. This is a CPD series designed by the Absolute Global Initiative in order to create awareness concerning virtual law practice. We ordinarily uh, we would be talking about money, how people um, can pay for this particular course, but we are not interested in that. In adopting such approach as far as this particular uh, CPD series is concerned. Our focus is how to create awareness concerning uh, uh, virtual law practice and how we can get lawyers to begin to embrace it, to see it as a norm, not something that is difficult. So in today's CPD series, in today's virtual law practice class, we are going to talk about e-filing, e-documentation, data privacy, as they all relate to clients' confidentiality, while also taking into account some while also taking into account the relevant provisions, some relevant provisions uh, of the Nigeria Data Protection Regulation, as well as the Cyber Crimes Act, as the case may be. In short, our focus is on the the Nigeria Data Protection Regulation, uh, the relevant provisions which basically uh, talk about data privacy. We may not be uh, too detailed, or we may not be detailed about it, but you, at the end of the day, you'll be able to have an idea of what personal data is, and uh, whether your client's data can be termed a personal data in the light of the the regulation, and how you can protect your client's data, what you need to do in order for you to protect your client's um, information. The, these things are important for you to succeed as a virtual lawyer, because you cannot be a virtual lawyer when you don't know how to secure uh, uh, processes which are supposed to be transmitted electronically, and which you have transmitted, but somehow you have a problem with securing them. The question is, how do you go about securing the processes? So these are some of the the issues that we are going to discuss in this particular series. So I think it is time now for us to look at the nitty gritty, what we understand by personal data first, because if you don't understand um, what personal data is, you won't be able to know how to classify some uh, information uh, that should fall within the purview of uh, information that we can call the personal data of your clients. So it's important that you know what is personal data in the light, or in light of the Nigeria Data Protection Regulation, and to also know whether your client's data can be can be classified as a personal data. Uh, and if that is the case, at what point can you become, or at what point can it be said that you are now a data controller? And if you have answered that question, the next question will be, who is a data subject? So if you are a data controller, the other person on the other side whose data you are controlling, or the other person on the other side whose data you are in charge of, is expected to be the data subject. Okay, what about the person that you um, are transmitting the data to? In other words, the party on the other side. What does the law say about such person? Is that person a data subject or a data controller, just as you are? These are questions that will be asked, as the as we continue to unveil these emerging realities in this particular course. So I think we just have to do something about going straight away to the screen share of what we want to discuss as part of the emerging realities in virtual law practice as of today. Let's go straight away. Okay, I think from what you can see here, we have a question to start the day's talk. It's a talk, so don't expect a regimented approach in discussing whatever we are going to discuss today. Now, we have a question here. The question is, can court processes in electronic formats be termed personal data? Can court processes in electronic format be termed personal data? This is a very good question. And I think the only way we can answer this question is to actually take a look at what personal data is. That is the only way we can actually know whether court processes can be classified or can be termed personal data. Now, and to do justice to this particular question, we have to look at what Section 1(3) of the Nigeria Data Protection Regulation has to say. Section 1.3, as it is um, described there. Now, just look at what we have on the screen. Here we have the meaning of personal data. Personal data, has been defined in the regulation, is any information relating to an identified or identifiable natural person called a data subject. An identifiable natural person is one who can be identified directly or indirectly, in particular by reference to an identifier such as a name, an identification number, location data, an online identifier, or to one or more factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that natural person. It can be anything from a name, address, a photo, an email address, bank details, posts on social networking websites, medical information, and other unique identifiers such as um, MAC address, IP address, IME number, IMEI number, IMSI number, SIM, and others. So, with what we have actually defined, or with what the regulation has defined, as stated to be personal data, the question now is whether a court process can be termed a personal data. Okay, at what point can a court process be termed a personal data? This is a question that is begging for answer. But if um, if one is to do justice to a question like this, it is good for one to ask oneself as a virtual lawyer. You are you need to ask yourself this question as a virtual lawyer: what is the relationship between you and your client? If the relationship between you and your client is that of you rendering services for your clients, in which case it is expected that your client's data, your client's court processes uh, are supposed to be under your care. Relevant information concerning the matter are supposed to be under your care. Then court processes under the care of a virtual lawyer, of a lawyer who provides legal services on behalf of his or her clients, can be termed personal data, going by the definition of personal data under the Nigeria Data Protection Regulation. I I don't think that there is really much there is really any issue concerning this. We are not talking about court processes that are in the courts. What we are talking about here uh, is simply that where you have court processes that you are using or which are supposed to be under your care, taking into account the fact that you are handling or you are doing a matter for a particular client, or you are being briefed by a particular client to handle a matter for him or her. Such court processes are processes which can be classified as your client's personal data because they are supposed to be under your care. That doesn't mean that they are not public documents. They are public documents. They can be accessed manually in the courts. However, there are some vital information. There may be some vital information that are supposed to be under your care. So if we are looking at personal data from the point of view of vital information that should be under your care in a particular court process or in court processes, then such court processes can be termed the personal data of who? Of your clients, in which case you are expected to protect them. You are expected to keep them safe. Your client's file constitutes the personal data or personal information of your clients. You are the data controller, while your client is the data subject in this case. If you are expected to transmit such court processes to the court or to serve the party on the other side or counsel on the other side, such the party on the other side is called the recipient under the Nigeria Data Protection Regulation. Now let us look at what the law says about the data controller. So the data controller means a person who either alone, jointly with other persons, or in common with other persons, or as a statutory body determines the purposes for and the manner in which personal data is processed or is to be processed. This definition is clear. So if you are to determine the manner in which your client's personal data is to be processed or is processed, as the case may be, what happens? You, the virtual lawyer, or the lawyer briefed by a particular person called your client, as a matter of fact, under the law, must be a data controller. That is a position. If you are expected to transmit, to serve the processes on parties on the other side or on the lawyer on the other side, that process or the processes, as the case may be, can be classified as the personal data of your clients. It is arguable. It is not absolute. So let us not take it as something that is absolute here. It is arguable. So I must emphasize it here because virtual law practice is just evolving. It's a new area of law. As time goes on, we'll begin to know the kind of data that can be termed personal data and that which cannot be termed personal data. But for now, if we take a look at the data protection regulation, it is submitted that your client's data as a virtual lawyer, if such data is under your control, your client's file as a virtual lawyer, if such file is under your care, your client's documents as a virtual lawyer, if such documents is under your care, documents meant for prosecuting the matter as the case may be, such document, such process can be termed as what? The personal data of your clients. Now let us look at processing. Processing. What is the meaning of processing? So processing means any operation or set of operations which is performed on personal data or on sets of personal data, whether or not by automated means such as collection, recording, organization, structuring, storage, adaptation, or alteration, retrieval, consultation, use, disclosure, by transmission, dissemination, or otherwise making available, alignment or combination, restriction, erasure, or destruction. So if you just take a look at what we have, look at this definition very well, you will know that as a virtual lawyer, you process the personal data of your clients. In the course of consultation, you process the personal data of your client. In the course of retrieval, you process the personal data of your client. In the course of storage, you process the personal data of your client. In the course of organization, you process the personal data of your client. In the course of collection, you process the personal data of your client. In the course of recording, as the case may be, recording information, taking brief through any audiovisual means, you process the personal data of your client. And what about restriction or erasing, as it were, or destroying. These are all um, uh, considered as what? As part of processing. So if you destroy the personal data of your clients, what are you doing? You have processed the personal data of your clients. The question is whether or not you have the consent of your clients to what? To destroy the personal data of your clients. You can process to save, you can process to collect, you can process to record, you can process to organize, you can process to restructure, you can process to retrieve, you can process to consult, you can process for use, basically for the purpose of litigation. You can also process for disclosure by transmission. Look at this one, disclosure by transmission. Can't you bring, is it not possible for us to bring in court processes here? You process the process, you process the court process, as the case may be. You, you, you then you what? What is the next thing you do? You transmit that particular court process to who? To maybe the party on the other side. That is what? Processing. So we don't have any problem here. And what about data subjects? A data subject, as it were, means an identifiable person. It is one who can be identified directly or indirectly, in particular by reference to an identification number or to one or more factors specific to his or her physical, psychological, mental, economic, cultural, or social identity. That is the meaning of a data subject. In this case, your client as a virtual lawyer is what? Your client as a virtual lawyer is what? Is who? Your client as a virtual lawyer is what? Your client as a virtual lawyer is an identifiable person. Take note, this is an interactive class, so I assume that the people, the participants here are following what I am doing here. They are following it, so it's like I'm teaching it, but in an interactive way. So don't expect me to adopt a regimented approach. Now let's go back to the topic. The data subject means an identifiable person, or one who can be identified directly or indirectly, in particular by reference to an identification number or to one or more factors specific to his physical, physiological, mental, economic, cultural, or social identity. What this means is that the data subjects can be identified by certain fixtures or certain characteristics, which may be physical, psychological, mental, economic, cultural, or social identity, as the case may be. And you are expected to what? To protect the personal data of who? Of your clients. Now let's look at some other emerging realities in virtual law practice. Take a look at data portability. Data portability means the ability for data to be transferred easily from one IT system or computer to another through a safe and secure means in a standard format. That is the meaning. Your WhatsApp, through which you transmit court processes to your client, has a portal has a link, and that particular link has the effect or has the ability for any data that passes through it to be transferred easily from that particular WhatsApp contact, from that particular WhatsApp contact, or from that IT system, or from an electronic format system, which could be a computer, to another through a safe and secure means in a standard format. That is it. So as a virtual lawyer, your business is actually transacted. Your business is actually carried out through online portals. These online portals could be um, in the form of websites. They could also be in the form of portals that you have embedded in um, some virtual platforms, which could be WhatsApp, be Telegram, could even be an electronic uh, mail. So that is it. So I do not think that there's any problem with the meaning of data portability here. Why we are actually doing all this is to enable us lay the foundation for what we are going to do next, which is e-filing and e-documentation. Because what you transmit through um, any of these virtual platforms, any of the online portals or what have you, is data. The question is whether or not such data can be termed a personal data. But as time goes on, we'll be able to know whether such data can be lawfully termed personal data. But I have submitted that any data that is transmitted by the virtual law office or a platform of a particular lawyer for and on behalf of a client to um, an adverse party or to the party on the other side can, in the light of the Nigeria Data Protection Regulation, be termed the personal data of a particular client. So that is it. Now let's look at recipient. A recipient means a natural or legal person, public authority who accepts what? Data. So if the courts accept whatever court processes that whatever processes that you transmit to the court clerk accepts it, receives it for and on behalf of the court. You know, the court is a public authority. Can't such processes be termed personal data? That is a question, it's a teaser we should begin to reflect on it. So the recipient means a natural or a legal person, a public authority who accepts data. So that is it. Now, what about personal data breach? Personal data breach means a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data transmitted, stored, or otherwise processed. This is clear. So, when you unlawfully destroy your client's case file in your virtual platform, in your virtual law office. That can turn personal data breach under the Nigeria Data Protection Regulation. If you take a look at what we have on the screen, you will observe that personal data breach is a very serious issue under the Nigeria Data Protection Regulation. Going by the definition, the virtual lawyer should know that he or she is expected to secure or to protect whatever portal through which he transacts or she transacts with his or her clients. Failure to so do will amount to something like this, which is called personal data breach. It has its consequences. Where counsel transmits a notice on behalf of his clients to the court through any electronic format or IT system, such notice can well be called the personal data. Now, let us look at privacy and electronic notices. Privacy and electronic notices. Let us ask ourselves this question. Does the Nigeria Data Protection Regulation apply to privacy-related issues and electronic notice as well as court processes? Section 1, Section 1.2 or Section 1 sub 2, as in whichever way we can state it, under the regulation clearly tells us or clearly provides that the regulation applies to all transactions intended for the processing of personal data and to actual processing of personal data, notwithstanding the means by which the data processing is being conducted or intended to be conducted, and in respect of natural persons in Nigeria. This regulation applies to natural persons residing in Nigeria or residing outside Nigeria, but of Nigerian descent. And this regulation shall not operate to deny any Nigerian or any natural person the privacy rights he is expected to under any law, regulation, policy, contract for the time being enforced in Nigeria or in any foreign jurisdiction. Now, look at this. So, if by the interpretation section notices, by the interpretation sections, in fact, I think this part is not important because if I'm to look at it, I will have to look at it from uh, the um, the the practice directions of the various courts in Nigeria. So let me just skip this and discuss uh, some other things, some other issues here. Now let's look at data portability and the ECMS WhatsApp-based portals. I must emphasize here that the focus of this particular virtual law practice series is to create an awareness concerning how to use your WhatsApp to serve court processes, transmit court processes to your clients, transmit court processes to the court. So that's our focus here. And if you don't actually know what the law says about privacy, about data portability, about the portals with which you can use to transmit these processes, it will be difficult for you to really understand the dynamics in virtual law practice. That is why this talk series is important. It's an interactive talk series. You can ask your questions by way of live phone-in um, calls. By the Nigeria Data Protection Regulation, data portability means the ability for data to be transferred easily from one IT system or computer to another through a safe and secure means in a standard format. Now the question is WhatsApp Business an IT system? Your WhatsApp Business, which you use as your law office, which you have configured as your 5G virtual law office, or as your 1G virtual law office, or as a 2G virtual law office. Is that WhatsApp law office an IT system, or is the law office you configured on your WhatsApp an IT system? If so, will it also be proper to classify ECMS, which is Electronic Case Management System, WhatsApp-based portals, as IT systems? This is a good question. And I think it's important that we begin to reflect on how we can use our WhatsApp to electronically manage our files, our cases, our court processes, documents that are under our care, which we're expected to keep safe for our clients. In other words, your WhatsApp can be used as an electronic case management system. Let me emphasize here, I am not talking about your WhatsApp socials. The kind of WhatsApp version I'm talking about here is the WhatsApp business. There is a difference between WhatsApp social, WhatsApp for socials, and WhatsApp for business. So the one I'm talking about here is WhatsApp for business. That is what you use as your that is what you use to configure your 5G virtual office. It's important you take note of it. And I make bold to inform you that your WhatsApp business can be well classified as an IT system, and it can be used as an electronic case management system. The reason being that um, it can be configured in such a way that you will have different portals with which you can use to transmit uh, the personal data of your clients uh, to which you can transmit the files of your client, processes of your client, or your client's documents to your client, or to the lawyer on the other side, or to the court, as the case may be. So Your WhatsApp business is an IT system, and your electronic case management system configured in the WhatsApp with portals embedded in the WhatsApp, as it were, can well be classified as IT systems. One other question we need to ask is, have the electronic case management system built on your WhatsApp um, portals protected by way of the end-to-end encryption? The answer is yes. Let me just ask the question the way it is on the screen. Say, are the ECMS WhatsApp portals end-to-end encrypted? The answer is yes. Why? Every portal in the ECMS WhatsApp based portal has a link through which you can access whatever information you need to access in that particular portal. So if you don't have the link, you cannot access it. So your ECMS WhatsApp based portals, as a matter of fact, are secure because they are well encrypted with codes well programmed. Now, do the ECMS WhatsApp portals protect clients' confidentiality? The answer is yes. The ECMS WhatsApp based portals protect clients' confidentiality. Why? It is because they have end-to-end encryption. And you, the lawyer, the virtual lawyer, can control it. So you can use it the way you want to use it. You can control it in whichever way you want to control it. That is why it is safe to say that when we are talking about personal data, any information that we have at our disposal to protect, to keep for our clients can be termed our client's personal data. In which case, as virtual lawyers, we're expected to protect them, or we're expected to protect it with our ECMS WhatsApp based portals. One question that we should ask here is, in which way can we actually configure our WhatsApp in order to have these features? I think that is going to be a talk for another time. Now let us look at what law technology today says about how we can secure, how we can protect the personal data of our clients as virtual lawyers. Law technology today suggests taking the following steps for in order for you to secure or to ensure remote security for your clients, or in order for you to protect clients' confidentiality. The first thing that you need to do is to invest in infrastructure. This is important. Investment in infrastructure could be in the form of your downloading softwares, apps that will enable you to know how to secure your clients' personal data in a remote way. The second thing for you to take note of is how to use cloud-based systems wherever possible. Now, how do you go about this? You are expected to back up your client's data on your WhatsApp with cloud-based systems. A good example is backing up your WhatsApp contacts, messages, and what have you with Google Drive. And you can access them at any time. So in the event anything happens to your WhatsApp, maybe you misplace it, or maybe it is stolen, or something terrible happens to it, you won't have any problem concerning how you can retrieve the information, the data, the files, the documents you have stored in the WhatsApp. You don't have any problem about it. And number three, you need to learn how to change passwords regularly. Because if it is observed that your passwords can be accessed at any time, it immediately means that you cannot protect your client's confidentiality. So you need to be mindful about the use of passwords. You need to know how to use them. You need to know how to change them. You need to know how to use codes. Learn to use hash, plus, numerals, numbers with letters, uppercase and lowercase, to protect your password. And it will become difficult for anybody to really know how to use it. So you have to learn how to change it regularly. Number four is for you to stay current with software updates. You see, the virtual lawyer is a lawyer who must be online, who must be up to date, who must be abreast with everything that is happening in the virtual world. You cannot run away from it. There is no way you can run away from it. You have to stay up to date with emerging realities concerning new versions of software. It's very, very important. For instance, the WhatsApp business of let me say, okay, WhatsApp of 2 years ago, the WhatsApp version of 2 years ago, and the WhatsApp version of today, they are not the same. It's been updated. So if you have not updated your WhatsApp version of 2 years ago, it will be difficult for you to actually follow the trend. So it's important that you know how to um, um, stay current with software updates. It's very important. And number five is for you to secure all devices. You need to secure all your devices. You need to this is not just the virtual platform now. This is not the WhatsApp. This is the phone itself. You need to know how to secure it. You can use codes. And the only way anybody can access your phone is by a code. So it is you are the only person that should have access to the code with which you can access the information on your phone. So you need to learn how to do it. If it's your system, your computer, desktop, laptop, as the case may be, you've got to learn how to secure the laptop. You've got to learn how to use all different kinds of security for it. Yeah. Now, let us talk about e-documentation. We have discussed, privacy, a lot of things and all that. So, because you need to, that's the foundation. When you have known how to, uh, uh, how to, when you have known the relevant laws concerning um, how the relevant laws that regulate how you keep your client's information to protect your client's information will be easy. That's the reason we decided to go through the 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 process of trying to help us to reflect on some emerging realities in virtual law practice, which led us to ask this particular question. Say, can court processes in electronic format be termed personal data? If you don't know this, there's no way you can actually know what is. You can understand e-documentation as it were. There's no way you can actually understand e-filing, as the case may be as well. So let us look at e-documentation. What is e-documentation? What do you understand by e-documentation? E-documentation. E-documentation is simply what we know very well. It is a process by which information is recorded in a manner that requires a computer or other electronic device to display, interpret, and process it. And whatever we are doing here in this process could be text, it could be graphics, it could be spreadsheets generated by a software and stored on a magnetic media. Or this magnetic media, of course, it is called disk. Could also be stored in optical media, otherwise known as CDs and DVDs. It could also be stored in an electronic mail. Of course, we are used to it. Um, and transmitted in electronic data interchange. Transmitted by electronic data interchange. For instance, I transmit court processes to the court. I transmit processes I want the court clerk to the court official to file for and on behalf of my clients. If I transmit it via my WhatsApp contacts or my 5G virtual office on my WhatsApp, what I have done is that I have done something relating to e-documentation. It is not paper-based documentation. It's something relating to e-documentation. So that is it. Now, this is in contrast to the conventional hard copy documents that we all know very well. Um, what you have, what you transmit electronically, if it's a document, is called a soft copy. But if you print it out, it becomes what? A hard copy. And that becomes the paper. It's paper. So the e-document could be in a Word format or in a PDF format. It could be in JPEG, meant for images, or any other format acceptable for the purpose of e-documentation as may be described. Data transmitted through platforms like WhatsApp, emails, Telegram, Facebook are examples of data transmitted through the process of e-documentation. Now let's look at e-filing, and so that we can actually know how to use the e-filing system with the 5G virtual office. E-filing, otherwise known as electronic filing, is the automated transmission of legal documents from a lawyer or from an attorney, uh, or a party, or someone who is self-represented, as a litigant, a self-represented litigant, to a court, or from a court. In other words, you have the document, take for instance, there is an order that you be served hearing notice as counsel representing your client, and the order is to the effect that such hearing notice be transmitted by your WhatsApp, by the WhatsApp contact number of the court clerk to you. That is e-filing. Any document transmitted through a WhatsApp contact, through a virtual platform, through email, through any IT system is called e-filing. Anything done like that, anything done like that is called e-filing. So where you have hearing notices being served on parties on the other side, hearing notices being served on a particular party, hearing notices being served on a lawyer or on counsel, hearing notices being served on counsel on the other side, or adverse counsel, as the case may be. Such is called e-filing. There's no big deal about it. There's no big deal. It's not really big. So a lawyer will find the 5G virtual law office plus very useful because of its easy to use functionalities and WhatsApp compatibilities. I must say here that e-filing, e-documentation, client confidentiality are emerging realities in virtual law practice, which, as a matter of fact, today's lawyer cannot run away from. At this point, I want to believe that you've been able to understand what um, e-filing is all about. I also want to believe that you now have an idea about e-documentation. E-filing and e-documentation go together, as the processes are on your WhatsApp, as they are on your phone, as you store the processes, as you store your client's documents on your processes, as you keep everything there, as you process them, That is e-documentation. If you are transmitting such processes to the parties on the other side, or to the lawyer on the other side, or to the court, that is e-filing. It's very easy. E-documentation is the document, as it were, put in an electronic format, while e-filing is the transmission of that particular e-document to where? To the court, or to anywhere you want that particular document to go. It could be you serving um, a party on the other side a court process by virtue of an order of court. That is e-filing. With this, I want to believe that we now have a good understanding about virtual law practice. Um, we, um, we should know that virtual law practice has come to stay. There is no way we can actually do without it today. We need to know how to use um, our WhatsApp to practice as virtual lawyers. The WhatsApp model is a good model. The reason being that it is a model that is cheap, it's a model that is affordable, it's a model that you can use for electronic case management system. It's a model that you can you can take care of. You don't need you don't really need you don't need so much money for you to know for you to invest in the use of WhatsApp as a virtual law office platform. The 5G virtual law office is good for you. I urge you to take advantage of this opportunity of using WhatsApp as a platform to provide legal services. It's good you know how to use WhatsApp very well. If you know how to use WhatsApp, I must let you know that using WhatsApp for as your law office is not going to be difficult. But that is not to say you cannot have your website. You can have your website. You can have um, some other platforms for a law office. But we recommend WhatsApp because virtual law practice is an emerging area. So WhatsApp is more like the foundation. You start with the basics, with the foundation. After this particular level, you can now transit to the medium, um, the medium platform, the medium virtual platform. Um, then you can go to the advanced. At the advanced level, what you do is for you to have a full scale website where you have a client portal where the client can log in at any time to access relevant information about his or her case, which you are handling for him or her. And that portal or that link has got to be very much protected. And you know what it is. You have to be funding. You have to. There's a certain amount of money you've got to pay for you to fund the site, you need to, it's like you're renting an office space. So in this particular case, you are renting an office space, a virtual office space. So in most cases, people have actually come to observe that using websites may be technically too expensive. So they have uh, come up with some measures that will make practice easy for them. Some just stay put with using their emails and their phones. But now you have WhatsApp, WhatsApp-based law office, which is a 5 dimensional office, and it's good for everybody, even the lawyers who have websites with secure client portals. If they if they know how this model of law office works, I tell you, uh, they will definitely develop interest in it and begin to use it to supplement the conventional website based virtual office. This is the WhatsApp based virtual office. So you have the WhatsApp based virtual office, you have the conventional website based virtual office. This one is a WhatsApp based. I recommend it for everybody. I expect that we will enjoy the use, and in all, we will begin to practice law in a unique way. I urge you all to embrace virtual law practice. It's good for the justice administration system in Nigeria. It promotes quick dispensation of justice, as it helps to promote speedy trials. Uh, you don't need to manually do some of these things, which um, tend to have some administrative bottlenecks. So when you transmit your processes to the court, or when the court transmits record processes to you, and you can immediately respond and serve on the party on the other side. You can do everything electronically. You don't need to be in court for you to do everything. We are not even talking about the website based um, e-filing now. We are talking about an e-filing model which you can use your WhatsApp to do. It's not a website based, the conventional website based e-filing model. This one is a WhatsApp based e-filing model. So you use it. It's good. It helps the system, and it makes practice a fun. I want to believe you have enjoyed um, yourself with what we have discussed, so far. If you have any question, you can contact us and ask us your questions. We are there to respond to them to the best of our knowledge, in line with the law, as well. And we do hope that um, you will find time to go back to watch this video again, in order for you to take down one or two things which you may find useful in your virtual law practice. The talk series is a continuous talk series, so it doesn't stop. So it continues like that. We will be coming up with different topics, different in fact emerging realities in virtual law practice, that will make us to begin to enjoy virtual law practice, and to also help us not to see virtual law practice as uh, a rocket science. I want to thank you for your patience. I hope to see you again. Thank you very much.